Hi, my name is Steve Sugarman. I'm an attorney and mediator with the law firm of Pusatier, Sherman, Abbott, and Sugarman. I practice collaborative law and I believe in it strongly. This methodology is excellent for parties going through a separation or a divorce or other family law type of a dispute. Let me explain the process. Each party engages a collaboratively trained attorney. And that is an attorney that is trained in communication skills, negotiation skills that are non-adversarial in what we call more of a problem-solving methodology. So that when we get to the table, my client and I, we meet with the other attorney and client, your spouse, and we have much less of an adversarial process, more of a problem-solving process, where we look at each issue of a divorce or separation, whether it's support, whether it's child custody, custodial access, distribution of assets, maintenance, spousal maintenance, and we talk through these things in a way that we express ourselves, what our needs are. We want to hear and understand what the other side's needs and goals are, as well as we get the children's needs and goals on the table if there are children in the situation. And we really brainstorm and try to come up with an agreement that everybody can live with and that's best for the children. We also at times have a team that we engage in this process. For instance, sometimes we bring in a financial planner as part of the team. Other times a mental health counselor or an accountant. And those people help us to process the facts and come up with a solution that is best for everyone. My ethical obligation in a collaborative law process is to protect my client's interests. But part of that is to recognize that my client's interest is to come out of this as unscathed and undamaged, so to speak, as possible. What I mean by that is we look for ways of coming up with a win-win solution as much as possible. So I'm looking out for my client's interest, but one of my client's interests by definition is coming up with a solution that, as much as possible, works for everybody and that the other side is satisfied with. So those are my marching orders, and those are the other attorney's marching orders. So imagine a situation like that where we're not trying to attack each other just for the sake of attacking, but instead trying to attack the problem instead of each other, trying to problem solve and come up with that agreement that works. Once you come up with an agreement, it's signed by the parties and it becomes a separation agreement and then a divorce agreement if you're going to go that far. Some people just live under it for a separation. Other people right away have one of the lawyers file the divorce papers, but nobody has to go to court because you already have the agreement done. It's just what we call an uncontested divorce that is processed. So let me just tell you that the benefits of this. One of the benefits is that it is much less expensive than going to court and doing the litigation process. Another, it's a lot less time consuming. It's a lot more empowering. When you go to court, your lawyers go behind closed doors and negotiate for you. Here, you're really part of the process with your attorney as your teammate. This is better for parenting relationships because you're not doing this damaging, destructive litigation, but you're working with each other. And you leave the marriage with dignity instead of having, a war or even a circus in the courts. So this is a great process for people going through this. And if you are interested in finding out more, please fill out the form that is below and submit it to my office. And then someone from my office will contact you and set up a complimentary consultation with me where we can talk about this some more. Thank you.